So the Department of Justice just announced something called the Anti-Weaponization Fund, and I need people to understand how deeply abnormal this is. Hi, I'm Nate Charles, and welcome back to the Rule of Law Brief. According to the DOJ's own press release, this fund was created as part of a settlement agreement involving Donald Trump and the IRS. Trump agreed to dismiss various pending claims, including claims related to the Mar-a-Lago search and what the accompanying press release called the Russia collusion hoax, in exchange for the creation of this massive compensation fund. Now let's stop right there, because this is where the entire thing starts to fall apart. DOJ is attempting to portray this as if it were some sort of ordinary victim compensation mechanism with historical precedent. And they specifically cite the Obama-era Keep Siegel settlement as their comparison. But that analogy is enormously misleading. The Keeps Eagle litigation specifically involved allegations of racial discrimination in USDA lending programs affecting Native American farmers over a defined historical period. Whether you agree with every aspect of that settlement or not, the underlying claims were at least tied to identifiable conduct, identifiable agencies, identifiable victims, and identifiable legal theories. This new compensation fund involving Trump is radically different. So according to the DOJ, the fund exists to compensate people who allegedly suffered weaponization and lawfare. Now, what exactly does that mean? I have no idea. The press release from DOJ doesn't really tell us, and there are almost no articulated standards for who's going to get this money whatsoever. It could be the January 6th insurrectionists, but honestly, I don't know. Your guess is as good as mine. The outlines of this program, if you could even call it that, have no meaningful definitions, no objective criteria, no evidentiary threshold for how to prove a claim, and no limiting principle. Instead, this fund appears to give the politically appointed board members enormous discretion to decide who counts as a victim of weaponization and who doesn't. And that ambiguity is probably not accidental. So here's my take on what the true purpose of this fund really is. It allows Trump to claim vindication on the most serious charges that have been levied against him without ever having to prove any allegations in court. Give that a second to sink in. The most serious of the claims against Donald Trump is that he was responsible for the January 6th insurrection and that he unlawfully withheld classified information at Mar-a-Lago. And in fact, the record is quite clear on those things. I mean, if the law was actually operating the way it normally should and would, the Department of Justice would have him dead to rights on those activities. The problem is that if those claims actually went into litigation, evidence rules would apply, discovery would apply, witness testimony would apply, cross-examination would apply. As an attorney, I strongly assess that Donald Trump's claims against the IRS would have collapsed under actual evidentiary scrutiny, principally because Donald Trump actually did unlawfully retain classified information. And he actually was responsible for the January 6th insurrection. But Todd Blanche, our lapdog of an acting attorney general, has thrown President Trump an enormous bone. Todd Blanche, who previously served as Trump's personal defense attorney, approved this settlement structure. And in so doing, he has prevented those claims from ever being adjudicated on the merits. This settlement allows the administration to create the public impression that Trump was somehow vindicated while carefully avoiding the one place where the allegations against President Trump would actually have to survive scrutiny, a courtroom. And I want to speak personally here for a moment. At the time of the Russia investigation, I was a federal prosecutor in the Counterintelligence Export Control Section of the Department of Justice. The Russian investigation was handled by special counsel. It did not come directly through my office, but I have very close colleagues who were involved in that investigation, and I'm telling you, those charges were real. Don't believe the hype otherwise. At a bare minimum, there is almost no doubt that the Internet Research Agency was tasked by the Russian government to interfere with the 2016 presidential election. That is beyond any good faith dispute at this point. I was there. The idea that this Russian interference investigation was somehow invented political fantasy is completely absurd. Russian state actors absolutely interfered in the 2016 presidential election. It's not clear that their interference made a difference in the outcome, but they were there. The interference was real, and it was pernicious. Within the national security community, this is in no way seriously disputed. Not even close. The Internet Research Agency was real, the hacking operations were real, the dissemination operations were real, the counterintelligence concerns were very, very real. Likewise, the Mar-a-Lago investigation was not fabricated out of political animus. It involved the retention of highly classified materials after repeated government efforts to retrieve them. People can debate prosecutorial discretion, people can debate charging decisions, people can debate the scope of executive authority. But to pretend that these investigations were simply manufactured out of thin air for partisan reasons is historically false and a deliberate interference in the integrity of public institutions for malicious purposes. And that's what makes this entire anti-weaponization fund so dangerous, because it institutionalizes a political narrative that federal law enforcement itself is inherently illegitimate whenever it investigates powerful actors. That does enormous damage to public trust. And the irony here is extraordinary. People claiming to oppose the weaponization of government are now using the machinery of government to financially and symbolically validate an entire partisan grievance using taxpayer money and extraordinarily vague standards. This is not some grand triumph for justice. This is political theater masquerading as legal process. And I suspect that years from now, historians are going to view this for what it actually was: an elaborate public relations maneuver designed to create the appearance of exoneration while carefully avoiding the risks of actual judicial scrutiny. And in the process, it's doing nothing but further eroding public confidence in the federal criminal justice system, not to protect the rule of law, but to protect the ego and the political standing of one man.